discussion on Indian Constitution, the significant provisions and the preamble chapter, I would like to discuss on 9th schedule. So it was an addition. So the topic heading is 9th schedule, and a significant judgment is there in the Supreme Court about the 9th schedule. So I would like to help you in understanding what was that. And as I was mentioning in general about the schedules of the Constitution, I said 9th schedule deals with the judicial immunity. So even if a law passed by the Parliament, even if it is violating some of the fundamental rights, such a law cannot be declared as invalid, because that is coming under, it has been placed in the 9th schedule. So that is the purpose. So basically the 9th schedule was initiated by the Parliament to have speedy land reforms in the country, because majority of the people are still engaged in agriculture. Land reforms is a very tricky issue in our country even today. So the first government, that the Nehru government, wanted to initiate speedy land reform process. Then he realized that this land reform is a very controversial issue. Naturally, people will go to the court. There is right to property also there at that time for individuals. So they brought in a new concept called a 9th schedule was created, whereby if some of the laws are put in this category, such a law's validity cannot be questioned in a court of law. So that was the idea behind the 9th schedule. So 9th schedule was introduced to the Constitution in the First Amendment Act itself in 1951. So the provisions are such that any law which is put in the 9th schedule cannot be judicial review on that. Any law which is placed in 9th schedule cannot be reviewed by the judiciary. No judicial review. So that is the provision. But this continued for many years and many decades, and finally in 2007, in a Supreme Court judgment, the Supreme Court ruled that the acts placed in the 9th schedule of the Constitution, which makes any act which is placed in the 9th schedule will be immune to the challenges for the violation of fundamental rights. So basically, what is that? Any act placed in the 9th schedule will be immune to the challenge for violation of fundamental rights. Will be immune to the challenge for violation of fundamental rights. That means you cannot be challenged in the court for violation of fundamental rights. Now, in 2007, a constitution bench declared that even those acts which are placed in the 9th schedule will be open for judicial scrutiny. The 2007 judgment will be open for judicial scrutiny. So Supreme Court, a 9-judge constitution bench, at that time it was headed by the Chief Justice Y.K. Sabharwal, delivered this historic way. So a 9-judge bench headed by the then Chief Justice of India, Y.K. Sabharwal, delivered this judgment. So it said justification for conferring protection. See, there can be justification for giving some protection to some laws, but not blanket protection. So Supreme Court said that there can be justification for protection for some laws, but not blanket protection. So Supreme Court is insisting that there can be protection for some laws, but not in a blanket protection for all those laws which are put in the 9th schedule through. Because it can affect the fundamental rights of the people. So, it depends on the nature and extent of the violation of the fundamental right. Supreme Court says whether it can achieve, whether it can enjoy this immunity depends upon the nature and extent of the violation of the fundamental rights. Supreme Court says this immunity depends on the nature and extent of the violation of fundamental rights. So, that is what court is saying. So, but at the same time, Supreme Court upheld the validity of Article 31B. Supreme Court also said that Article 31B is valid. What is Article 31B? It empowers the Parliament to place a law in the 9th schedule. So, Article 31B is valid and Article 31B empowers the Parliament to place laws in the 9th schedule. Empowers the Parliament to place laws in the 9th schedule. So, what is the crux of the matter? So, Supreme Court is saying that 31B is where, that means Parliament are still free to place any law in the 9th schedule. That means there will not be any judicial scrutiny for violation of fundamental rights. See, the Constitution, please understand, our Constitution is very clear. Through Article 13, we will come to that later on. To Article 13 is clear, any law which violates fundamental rights should be declared invalid by the Supreme Court. Now, when 9th schedule is there, if a law is placed in the 9th schedule, then Supreme Court's power to review that, the Supreme Court's power to declare that law invalid if it is violating fundamental rights has been taken away. But Supreme Court again says it will depend upon the extent of the violation of the fundamental rights. So, 31B is still valid. You can place any law in the 9th schedule, there is no problem. But at the same time, Supreme Court will look into what kind of violation is going on, and if the violation is too big or there is no blanket immunity for this, Supreme Court will always have the right to check whether a particular law which is put in the 9th schedule should maintain that or not. So, it upholds the Parliament's power, and the court said that it is a limited power. So, Parliament has power, but Parliament has only limited power which is subject to judicial review. You cannot place anything and everything in the 9th schedule. Parliament's power, Supreme Court insisted in that 2007 judgment that Parliament's power in the 2007 judgment is a limited power. Parliament has power to place any law in the 9th, but you should consider it as a limited power, not like an unlimited power. It is subject to judicial review. And Supreme Court also said that the law placed in the 9th schedule after 1973 is open to challenge. One more interesting thing they said was that any law placed in 9th schedule after 1973 will be open to challenge. After 1973 will be open to challenge. That means any law placed in the 9th schedule before 1973 is not open for challenge. Why? Because this is the year. This is 1973, is a very landmark year for Indian law and the Indian judicial system. This is the year when the Keshwanda Bharati judgment case. See, this is a very landmark judgment. Supreme Court verdict came. This Keshwanda Bharati case was related to some land reforms and related issues from Kerala. Keshwanda Bharati versus state of Kerala. This has ultimately become the most important case in the Indian history. And in this case, Supreme Court came out with the concept of basic structure of the Constitution. I will be elaborately talking about basic structure separately. So, now since that is considered to be a watershed year in the history of Indian law, any law placed in the 9th schedule before this concept will not be reviewed, or any law which is placed in the 9th schedule after Keshwan Bharati judgment is open for review by the Supreme Court. That is what the 2007 judgment says. Now, while laying down the test to be adopted to examine the validity of the laws, I mean, while they have, Supreme Court has come up with certain tests regarding the validity of a law placed in the 9th schedule, Supreme Court said 2-3 things. Number one, Supreme Court insisted that Supreme Court will see if the law in question violated any fundamental right or not. First of all, it will check whether the law violated any fundamental right or not. The first thing Supreme Court will look into is if a law which is placed in the 9th schedule, is it violating any fundamental right or not in the first case, number one. If yes, suppose it is violating, if yes, then it will examine if the violation of the fundamental right amounts to the violation of the basic structure of the Constitution also. So, then they will say if or whether if that violation of a fundamental right, if whether that violation is violating the basic structure also, if that violation of fundamental right amounts to violation of the basic structure of the Constitution, violation of the basic structure of the Constitution. So, first of all, Supreme Court will look into this law which was made by the Parliament and which is placed in the 9th schedule, is it violating any fundamental right? Yes. If it is yes, whether that violation is amounting to the violation of the basic structure also. Then the third point is, if it is violating the basic structure also, then the final judgment will be based on the nature and degree of the rights which are violated. Okay. So, it will look into the nature and degree of violation. So, Supreme Court said, keeping all these things in mind, this 9th schedule, even if a law is put in the 9th schedule, the Supreme Court is open to review that law in the 9th schedule. So, again I am repeating, Supreme Court said that the power of the Parliament to put a law in the 9th schedule is still valid. Article 31B is still valid. So, there is Article 31B that is still valid. But Supreme Court reserves the right to review any law which is put in the 9th schedule to ensure that Parliament is not using any unlimited power in doing this. Only limited power. Parliament has only limited power to make a law. Supreme Court has the power to review and cross check and find out whether that power is rightly used or not. So, Supreme Court is maintaining its supremacy when it comes to judicial review. Supreme Court says it is a basic structure of the Constitution. So, any law which is passed by the Parliament, which is put in the 9th schedule, ideally it should not violate the fundamental rights. Even if it is violating the fundamental rights, it is okay. But if it is violating even the basic structure also, then such a law may be reviewed by the Supreme Court and the Supreme Court will declare that law invalid. So, once again, 9th schedule is a provision whereby any law which is placed in the 9th schedule, there is judicial immunity. There is no judicial review. Judicial review is for whether this law is violating any fundamental right or not. So, this immunity is not provided, or rather Supreme Court can review that depending upon the seriousness of the case. So, this 9th schedule was introduced to the Constitution in 1951 by the First Amendment Act. Till now, since then, so many laws were placed, more than 280 plus laws have been already put in the 9th schedule, and including some of the controversial laws like 69% reservation. 69% reservation in Tamil Nadu in government jobs. Even that law which is passed by the Tamil Nadu government for the state of Tamil Nadu has been put in the 9th schedule by the Parliament under political pressure at that time. So, more than 280 plus laws are put in the 9th schedule. Now, the Supreme Court is saying that yes, you can put it in the 9th schedule, but I reserve the right to review that if required. If it feels that there is a blatant violation of the fundamental rights, and this is also a violation of the basic structure also, Supreme Court may declare such law invalid. But right now, if it is put in the 9th schedule, Supreme Court has no right to review it, and Supreme Court cannot declare that law invalid. So that is the situation as far as the 9th schedule is concerned. More than 280 laws are put in the 9th schedule already, which is quite high. The idea was to have speedy land reforms, but subsequently the government, the parliament started putting even such laws which are not related to the land reforms are putting in the 9th schedule, whereby many people felt, that many experts felt that this is a misuse of the power of the parliament. Parliament is trying to become, by having unlimited power when it comes to their